The Supreme Court once again hears arguments to consider if businesses may deny employees access to free birth control. One America's Marty Golingan has the latest.
Oh yay, oh yay, oh yay. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
The Supreme Court takes up two cases concerning birth control coverage under Obamacare. The cases, Little Sisters of the Poor versus Pennsylvania and Trump versus Pennsylvania, ask whether an employer can limit an employee's access to contraceptives due to religious or moral objections. Under Obamacare, an employee's health insurance would cover the full cost of birth control. This exempted religious institutions like houses of worship, but organizations affiliated with the clergy like hospitals and universities can opt out of the contraceptive rule, leaving insurers or the government to pick up the tab for birth control. The Little Sisters of the Poor, an order of Roman Catholic nuns, say the law violates their religious beliefs and took their case all the way to the nation's highest court with the help of the Trump White House. The administration had put in place rules which would grant further exemptions to businesses and even publicly held companies, broadly stating any employer with a moral objection could opt out and deny contraceptive coverage. Liberal Justice Ruth Bader Ginsburg, who was teleconferencing from her hospital room after reported gallbladder treatment this week, argued that Congress specifically added birth control in the language of the Affordable Care Act and claimed that religious beliefs were being forced upon employees.
You have just tossed entirely to the winds what Congress thought was essential, that is that women be provided these services with no hassle, no cost to them. Instead, you are shifting the employer's religious beliefs, the cost of that, onto these employees who do not share those religious beliefs.
Conservative Justice Brett Kavanaugh disagreed with Ginsburg's assertion, saying the moral objection rules could be enforced as long as it is considered reasonable. Solicitor General Noel Francisco, who argued for the Trump administration, also pushed back against Ginsburg, citing the 2014 Hobby Lobby ruling, which overrides the contraceptive mandate for religious reasons.
Yes, respectfully, Your Honor, I think I would disagree with the premise of your question, because there's nothing in the ACA, as this court recognized in Hobby Lobby, that requires contraceptive coverage. Rather, it delegated to the agencies the discretion to decide whether or not to cover it in the first place, and we think that that also includes the discretion to require that most employers provide it, but not the small number who have sincere conscientious objections, because otherwise the original church exemption likewise would be illegal, as would the effective exemption for self-insured church plans.
As the justices appear divided along ideological lines, Chief Justice John Roberts questioned the legitimacy of the Trump opt-out expansion, stating the administration's rules allow for reasons unrelated to religion. Pro-choice groups like Planned Parenthood claim if the rule is allowed to remain in place, then tens of thousands of women could be denied birth control coverage. The Supreme Court is expected to deliver its final ruling on the matter by late June. Marty Golingan, One America News.
Want to see more videos like this? Click on the link below and subscribe to One America News on YouTube, and call your cable provider and kindly demand that One America News is added to your lineup. Call and subscribe today.